Okay, let's dive in. Think about everything you create, that story you wrote, maybe the song you hummed into your phone, the photos on your camera roll. In today's digital world, hitting share can send your creation everywhere in an instant. But what protects that original spark? How does the law grapple with this fundamental tension between, the ease of sharing and the idea of ownership over creative work?
It's a challenge that goes right to the heart of creativity and commerce, isn't it?
Yeah,
Especially now when copy and distribution are, well, easier than ever before.
absolutely. And understanding that challenge is exactly why we're here. Welcome to the deep dive. Today, we're setting the crucial foundation for UK copyright law, and we're drawing our insights very specifically from material provided for students, excerpts from Chapter 6 of a University of London module guide.
That's right. And we really want to give full credit and express our gratitude to the University of London for making these educational documents available to their students. This deep dive, just like others we create based on educational materials, is intended purely for educational purposes.
And this particular deep dive is brought to you by Sinorbit Academy, Sri Lanka. To all of you studying this material, perhaps gearing up for exams, we want to wish you the very best of luck.
Indeed, good luck with that. Our mission today is to take this introductory chapter and really unpack it. We're going to trace the history of UK copyright law, figure out how it's distinct from other types of intellectual property rights, explore the core reasons why this legal protection exists, and then tackle what the material flags as a fundamental, perhaps the most challenging concept: the difference between protecting an idea and protecting its expression.
We're aiming to give you a really solid understanding of these basics, highlighting the absolute key points presented in this text, hopefully helping these concepts stick as you continue your studies.
And the material makes it clear that this chapter is specifically designed to prepare the ground for everything that follows in the module. Concepts like comparing copyright to other IP rights and understanding its justifications might echo things you've seen in earlier chapters, maybe. But the idea-expression divide is absolutely central. It underpins how courts determine what is protected and whether something has been copied. So grasping that distinction is, well, it's non-negotiable.
Understood. The absolute bedrock. So let's start there. At its very core, according to this material, what is copyright protection and how does it really differ from other intellectual property rights you might have come across, like patents or trademarks?
Okay, at its most fundamental level,
Mm,
copyright exists to protect creative works. It provides the creator, or the copyright owner, with a set of exclusive rights to control certain specific forms of use of those protected works. The Copyright Designs and Patents Act 1988, which we'll often just call the CDPA 1988,
hmm
it lists the categories of works it protects. Things like literary, dramatic, musical, and artistic works, sound recordings, films, and broadcasts. We're not getting into the detailed list of categories just yet, that's for a later chapter, but the focus is clearly on the work itself.
So it's about protecting the output of creativity, the actual song, story, or painting, and giving the creator control over it.
Exactly. And this is where we hit one of the most significant differences when you compare copyright to other intellectual property rights,
Mm.
like patents for inventions or registered designs for product aesthetics. This material emphasizes this point repeatedly because it's crucial. In the UK, there is no system of registration for copyright.
No registration, you don't have to apply or pay fees or anything.
Not at all.
Yeah.
Copyright protection arises automatically the moment the work is created and fixed in some tangible form. As soon as you write that first sentence of your novel, paint that stroke on the canvas, record that snippet of music, or save that line of code, copyright protection exists. You don't file a form, you don't pay a fee. This automatic nature is a defining characteristic of copyright globally, stemming from international conventions like the Berne Convention.
That's a huge practical difference compared to patents, where you have to go through a rigorous examination process, or trademarks and registered designs, where you file an application.
It really is.
Yeah.
And tied into this, the fundamental requirement for a work to qualify for copyright protection is that it must be original. Now, the material notes something interesting about originality in UK law, at least historically. It hasn't traditionally required a high degree of, say, innovation or novelty, especially when contrasted with some civil law countries that might link copyright more closely to the author's unique personality or truly groundbreaking creativity. UK law has historically approached copyright more as an economic right.
An economic right, so it's more about the commercial value and preventing commercial exploitation.
Precisely. The focus has been on preventing others from unfairly taking the economic value generated by the creator's skill, labor, and judgment. This emphasis on the economic right combined with a historically lower threshold for originality, has led to a situation where a wide range of works, sometimes seemingly quite mundane, can potentially attract copyright protection in the UK. The material suggests this scope might be broader than in some other jurisdictions. Think about things like lists, directories, or even exam papers. Copyright can subsist in these, provided they meet that threshold, however low, of originality based on skill and effort. We'll definitely get into what originality really means in more detail in the next chapter, Chapter 7.
Okay, so automatic requires originality, though maybe not a super high bar, you're saying, and it's primarily seen as an economic right. What happens if someone independently creates something very similar to my work?
That brings us to another key contrast. With absolute rights like patents or registered designs, copyright is not an absolute monopoly. If someone genuinely and completely independently creates a work that happens to be similar or even identical to yours without having copied from your work, they have not infringed your copyright. This is the crucial defense of independent creation.
So, if by sheer chance, another songwriter in a different country writes a melody that is exactly the same as mine, and they've never heard my song.
Under copyright law, they have not infringed. The burden of proof is on the person claiming infringement, the claimant, to show that the defendant actually copied their work, either directly or indirectly. This really highlights that copyright is about protecting against the act of copying, not protecting an absolute right over the underlying creation, regardless of its origin.
Right, it's the taking that's the problem. So, what does this act of copying or infringing use look like under UK law? The guide suggests the scope can be quite wide.
It can indeed be remarkably broad. Unlike some other IP rights, where infringement usually requires an action in the course of trade, copyright infringement in the UK can be committed in the home. Technically, even making an unauthorized copy of a CD or DVD for your own use in your living room could be an infringement, although enforcement of such private acts is, understandably, pretty rare.
Wow, infringement in the home. That certainly underscores the breadth. What else falls within that scope?
Well, it can involve indirect copying. You don't have to copy directly from the original work. Copying from a copy, or even a work that is itself a derivative of the original, can still trace back and infringe the copyright in the original work. It can also, in rare circumstances, involve subconscious copying. This is notoriously difficult to prove, of course, but courts have accepted that if similarities between two works are so striking and the defendant had access to the original, it can lead to an inference that copying occurred, even if the defendant wasn't consciously aware of recalling the original work.
That sounds tricky to establish.
It is. And importantly, you can be liable not just for copying yourself, but for authorizing others to infringe. This could happen if you provide facilities or platforms that enable large-scale copying of protected material by others.
Okay, that covers a lot of ground regarding how copying can occur, but what about simply buying and using a legitimate copy of something? If I buy a book or, I don't know, a piece of furniture that has a design.
This is another point the material clarifies. Generally, there is no liability simply for using a legitimate copy of a copyrighted article. Once you've lawfully purchased a copy of a book, a DVD, a piece of software, or a poster, you own that physical copy. You can lend it, sell it, frame it, or even, yes, use it as a coaster if you really wanted to, as long as you don't perform a restricted act. A restricted act is one of those exclusive rights belonging to the copyright owner, primarily involving making copies or communicating the work to the public.
So owning the lawful copy is fine, but photocopying the book, uploading the movie online, or making unauthorized copies of the software, those are the restricted acts.
Exactly. Now, there's a specific area where this distinction between use and copying gets a bit tricky, and that's with computer software. The material specifically highlights this blur.
How is software different then?
Well, to use a computer program, the software has to be loaded into the computer's temporary memory, its RAM. This act of loading creates a temporary copy of the program code. So the very act of using software inherently involves making a copy. A legitimate purchaser of software has an implied license that permits this necessary copying for the purpose of using the program. But someone who has acquired a pirated copy, a copy that wasn't legitimately licensed or sold, infringes copyright each time they use it, because each use involves making an unauthorized copy in the computer's memory.
Ah, I see. So with software, the line is crossed not just by getting the pirated copy, but by every subsequent act of running it. That makes sense. The guide also mentions that serious commercial infringement can lead to criminal liability.
Yes, it's not just a matter for civil lawsuits for damages or injunctions. Commercial-scale copyright infringement can lead to criminal prosecution, similar to offenses involving counterfeit goods. Section 107 of the CDPA 1988 lays this out. And the material references the case of Thames and Hudson v. Design and Artists Copyright Society that was 1995 to show that this isn't limited to obvious counterfeiting. It can apply to anyone making copies by way of trade, even if they're not trying to pass them off as originals, but are simply commercially exploiting unauthorized copies. Public bodies like Local Authority Trading Standards and HM Revenue and Customs often play a role in enforcing anti-counterfeiting laws, which certainly encompass commercial copyright piracy.
So distributing pirated goods on a commercial scale could land you in serious criminal trouble, not just a civil suit.
Precisely. Now, moving beyond single acts, the material makes an important point about the nature of copyright itself. It describes it not as a single monolithic right, but as a bundle of distinct exclusive rights.
A bundle of rights, what does that mean in practice? Like a pick and mix?
Sort of. It means the copyright owner doesn't just have one general right to stop people using their work. They have a collection of specific rights to control different ways the work can be used or exploited. The CDPA, in sections 17 to 21, lists these restricted acts. This bundle typically includes the exclusive right to control the reproduction of the work in any material form. That's copying. The right to issue copies to the public for the first time, distribution. The right of public performance, playing music or performing a play publicly. The right to communicate the work to the public, like broadcasting or making works available online via streaming or download. And the right to make adaptations of the work, like turning a book into a film script or translating it.
And the material uses a really clear example here, J.K. Rowling in the Harry Potter books.
It's a perfect illustration of this bundle concept. As the author, J.K. Rowling didn't just have the right to stop people photocopying her original manuscript, she owned the entire bundle of rights. She had the exclusive right to control the reproduction of her books in hardback and paperback editions. She had serialization rights for magazines. She had the rights for talking book versions. She had dramatization rights for the stage plays. Crucially, she held the valuable film rights, which she licensed to Warner Bros. She also controlled the broadcast rights for radio and television versions and the right to authorize translation into any language.
So she could slice up that bundle and license different pieces to different companies around the world.
Exactly. These distinct rights can be assigned, sold outright, or licensed, permission granted under specific terms, individually or collectively to third parties. This is how film studios, record labels, publishing houses, and broadcasters acquire the rights they need to exploit creative works. The material notes that these bundles of rights automatically exist in all countries that belong to the major international copyright conventions, like the Berne Convention or the WTO Agreement, which covers over 150 countries.
So automatic protection for this bundle of rights applies globally in member states. That sounds incredibly powerful for creators.
In principle, yes, the international framework provides that automatic protection. However, the material makes a practical note. With this fragmentation of rights across different categories of works and automatic protection in so many different national jurisdictions, tracing ownership globally can become incredibly complex. But it reassures the reader that for the purposes of studying this UK law module, the focus will be on the rights an author has under UK law derived from the CDPA.
Okay, let's stick to the UK bundle for now. You mentioned this protection lasts a long time. How long exactly? It's longer than patents and designs, isn't it?
Yes, significantly longer. The basic rule for works requiring originality, literary, dramatic, musical, and artistic works is the lifetime of the author plus 70 years. That's a considerable term compared to, say, patents, typically 20 years, or registered designs, up to 25 years.
So the copyright doesn't expire until 70 years after the creator has died. That feels like a very long time indeed.
It is. After this lengthy period expires, the work enters the public domain. At that point, anyone is free to use, copy, or build upon the work without needing permission or paying royalties. However, the material introduces a nuance. Subsequent amendments or revisions to an existing copyright work can gain new copyright protection in their own right.
Ah, like a new annotated edition of a classic novel, or maybe a colorized version of an old black and white film.
Exactly. The material uses the examples of the image of Mickey Mouse, or the emblem of a famous football team, treated as artistic works under Section 4 of the CDPA. If these visual representations are revised or updated, the new version, if it meets the originality threshold itself, can attract its own new term of copyright protection. This can potentially extend a form of legal control over aspects derived from the original work, even if the copyright in the very first version has expired or is nearing expiry. It's a way intellectual property rights can be layered and potentially perpetuate control.
That's really interesting. Control can be maintained over time through updates and revisions. Now, a practical point for anyone studying this, What about works created before the main current law came in? The CDPA 1988.
That's a crucial point the material addresses. The current relatively straightforward rule of life, plus 70 years, primarily applies to works created after the CDPA 1988 came into effect on August 1st, 1989. For works made before that date, you have to look back at the law that was in force when the work was created, potentially the Copyright Act 1956 or even the Copyright Act 1911, and then consult the complex transitional provisions within the CDPA 1988.
That sounds like delving into legal history just to figure out how long protection lasts. A bit of a headache.
It can be quite complex. The material acknowledges this, but offers a helpful reassurance for students. For examination purposes based on this guide, they can generally assume that the relevant events, the creation of the work, the alleged infringement occurred after August 1st, 1989.
Yeah.
So unless specifically instructed otherwise, they can apply the current CDPA rules without having to navigate the older legislation and transitional provisions.
Phew. Okay, good to know. Keep it simple for the exam unless told otherwise. Are there any other types of rights mentioned in the CDPA besides this economic bundle?
Yes. The CDPA also includes what are called moral rights and rights and performances. The material notes that rights and performances are typically not on the syllabus for this particular module, but moral rights are and will be covered later in Chapter 8. These moral rights are distinct from the economic rights we've been discussing and relate more to the creator's relationship with their work, such as the right to be identified as the author.
Okay, so that's a comprehensive picture of what UK copyright is. Automatic protection, focused on the economic right, requires originality, with a potentially broad scope, protects against copying, even indirect, subconscious, or authorizing others, functions as a bundle of distinct rights, reproduction, communication, etc., has a long duration, life plus 70 years for most works, with complexities for older works and revised versions, and sits alongside other rights like moral rights.
That captures the core nature of the right, as presented in this chapter, yes.
Fantastic. Let's shift gears now and look at the journey. Where did all this come from? The guide traces the history right back to the invention of the printing press.
Indeed. The very foundations of copyright law are directly linked to a major technological revolution in the 15th century, the invention of the movable type printing press. Before printing, copying documents was a laborious manual process, slow and limited in scale. Printing made rapid mass reproduction of texts possible for the first time.
And mass reproduction meant not just spreading knowledge, but potentially spreading ideas the authorities didn't like, I suppose.
Exactly. Under the Tudor monarchs, the initial concern wasn't protecting authors or publishers. It was about controlling the dissemination of potentially seditious or heretical material. Printing was seen primarily as a tool for censorship and control. This control was managed through a licensing system granted by the Crown to the Stationers' Company, a guild of printers and booksellers in London. They were given a monopoly, the exclusive right to print books, essentially to control what was published.
So, copyright's earliest ancestor was actually a tool of government control, not really a right for creators.
Precisely. That control system via the Stationers' Company persisted. However, printers and booksellers outside the company, or those operating without licenses, began copying books printed by the licensed members. This was the early form of piracy. The licensed publishers started losing significant money. Pressure from these publishers for better legal protection against piracy eventually led to the first true Copyright Act in 1709, known as the Statute of Anne.
The Statute of Anne, 1709. That sounds like a pivotal moment in legal history. What were its key features?
It conferred on authors and typically signed to publishers the sole right and liberty of printing books. This was the first time the right was established by statute, by an act of Parliament, rather than just a royal grant or guild rule. The term of protection was also limited, which was a key change. It was a maximum of 14 years from publication. And interestingly, if the author was still alive at the end of that first 14-year term, the right would return to them for a further 14 years.
A limited 14-year term with a potential renewal for the author. That's a far cry from life, plus 70 years.
Absolutely. This new statutory right immediately raised complex legal questions, though. One of the biggest debates was the relationship between this limited statutory copyright and the existing common law copyright.
Common law copyright. What was that?
Before the Statute of Anne, English common law recognized a perpetual right for authors over their unpublished works. The question was, what happens when a work is published? Does that perpetual common law right continue? Or is it extinguished and replaced by the new limited statutory right under the Statute of Anne?
And how did the courts resolve that? Sounds like a big deal.
The landmark case addressing this was Donaldson v. Beckett back in 1774. The House of Lords, after much debate, eventually held that once a work was published, the common law copyright was extinguished. It was replaced solely by the limited statutory rights granted by the Statute of Anne. However, common law copyright did continue to exist for unpublished works until much later, only being completely abolished by the Copyright Act 1911. The material notes that under the current CDPA 1988, published and unpublished works are generally treated the same for copyright purposes.
Okay, so the 1709 Act created statutory copyright. Donaldson v. Beckett clarified that publication meant swapping perpetual common law for limited statutory rights, and the 1911 Act got rid of common law copyright entirely. What happened after the Statute of Anne? Did things change much?
The 19th century saw a series of individual acts addressing specific issues or categories. The material describes this as piecemeal development. Legislation was passed to extend copyright to engravings, sculptures, dramatic works, musical compositions, and paintings, and to gradually extend the term of protection. These changes were largely reactive, responding to new creative forms emerging and persistent demands from creators and publishers for broader and longer protection.
So the law was constantly playing catch-up with technology and creative practice. Seems like a recurring theme.
Exactly. This theme of reactive development continues into the 20th century, but with a major new driver: international influence. The most significant factor shaping UK copyright law in the 20th century was the need to align with international obligations, particularly the Berne Convention for the Protection of Literary and Artistic Works, first signed in 1886.
Ah, the Berne Convention, a cornerstone of international copyright, right?
It is. Adherence to Berne was a major catalyst for the Copyright Act 1911. This was a significant piece of legislation, notable because it was the first UK act to consolidate various copyrights previously scattered across different statutes for different work types into a single piece of legislation.
So international pressure led to a big step in consolidating and modernizing UK copyright law in 1911.
Yes. That act was reviewed by the Gregory Committee in 1951, leading to the Copyright Act 1956. Again, this legislation had to account for newer forms of media that had emerged, particularly film and television. The 1956 Act was then amended several times over the next few decades, including specifically to deal with new areas like designs and, crucially, computer software.
Which brings us up to the current main act, the CDPA 1988.
Exactly. By the 1980s, the pace of technological change, particularly with the widespread availability of easy copying technologies like photocopiers, video recorders, and early digital methods, meant the 1956 Act was increasingly inadequate. There was a clear need for a comprehensive overhaul to protect newer forms of creativity, address these copying technologies, and provide more effective remedies. This led to the enactment of the Copyright Designs and Patents Act 1988, the CDPA 1988.
The CDPA 1988, did it completely replace everything that came before? Start fresh.
It made significant sweeping changes, but the material points out that Section 172 of the CDPA is important for understanding its relationship with prior law. It deals with how the Act should be interpreted in relation to the preceding legislation. Essentially, it confirms that while the CDPA is the primary law, it often builds upon, rather than completely discards, the principles and concepts developed under the earlier acts. So understanding the historical context isn't just academic. It can still inform how the current law is understood, confirming things like definitions or established approaches, unless the CDPA explicitly changes them.
Okay, so it's a continuation and consolidation, not a complete break. And since 1988, the CDPA has been amended a lot, mainly due to EU law.
Heavily amended, yes. Primarily to implement various EU directives, many of which, as the guide mentions, were likely discussed in Chapter 3 of the module. A key example is the Information Society Directive from 2001, which was implemented in the UK through the Copyright and Related Rights Regulations 2003. This directive itself had origins in international treaties agreed under the World Intellectual Property Organization, WIPO, back in 1996, the WIPO Copyright Treaty, and the WIPO Performances and Phonograms Treaty.
So the chain is often international treaty, EU directive, UK regulations, amending the CDPA. Quite a path.
Precisely. This illustrates vividly how UK copyright law hasn't developed in a vacuum, but is constantly influenced and shaped by global and regional agreements. It means UK courts interpreting the CDPA are often applying provisions that originated in international negotiations and EU law. The material also notes that moral rights were introduced into UK law as a result of these EU directives.
And finally, Brexit. How does the guide say that impacted this EU-influenced copyright landscape? Any major shakeup?
The material, referring back to earlier sections in the guide, states that rules derived from EU directives in the area of copyright law that were binding in the UK at the end of the implementation period continue to bind UK courts post-Brexit. This is because they are now considered retained EU law. So even after leaving the EU, much of the copyright law we discussed, particularly those parts introduced to implement directives, remains highly relevant and binding in the UK.
So the historical journey is quite a ride. Starting with Tudor control driven by printing technology, evolving through the Statute of Anne born from publisher pressure and piracy, grappling with common law debates, Donaldson T. Becket, undergoing piecemeal changes in the 19th century, reacting to new media, consolidating under international influence, Byrne in the 20th century, 1911 Act and the 1956 Act, a major overhaul with the CDPA in 1988 driven by new copying tech, and then heavily shaped by EU directives, the influence of which largely remains post-Brexit. It's a story of law constantly adapting, often reactively, to external forces and particularly technology.
It's a prime example of how technology is a relentless engine of legal change. Definitely.
Okay, we've explored what copyright is and how it got here. Now for the big why. Why does society grant creators these exclusive rights? What are the justifications for copyright, as explored in the guide?
The material refers back to the general theories of intellectual property justification likely covered in Chapter 2, and then applies them specifically to copyright. The principal theories mentioned are natural law theory, utilitarianism, and the reward theory.
Let's quickly revisit those. Natural law. What's the thinking there?
This perspective views copyright as an inherent natural right of the creator. It's seen as an extension of their personality or a moral right to control the fruits of their intellectual labor, much like owning physical property created by one's hands. The material notes this theory tends to be more prominent in civil law legal systems, where the emphasis on the author's moral rights is often stronger than in common law systems like the UK.
Okay. And utilitarianism. That sounds more economic.
This is perhaps the most dominant justification in common law systems like the UK and the US. The idea is that copyright is granted as a policy tool, a limited monopoly, to provide an incentive for people to create and disseminate new works. By giving creators a period during which they can control and profit from their work, the law encourages the production of cultural, scientific, and artistic works that ultimately enrich society as a whole. It's about maximizing overall societal welfare through incentivized creativity.
So society grants the right because it gets something valuable in return, more books, music, art, knowledge. It's a deal, sort of.
Exactly, it's a trade-off. A temporary private monopoly for a broader public benefit, and then there's the reward theory.
Reward theory, how's that different?
This justification sees copyright as a just way to reward authors and creators for their effort, skill, labor, and investment in creating a work. Creating original works often requires significant time, talent, and resources, and this theory argues that copyright provides a fair mechanism for creators to recoup that investment and be compensated for their contribution. It's less focused on future incentive and maybe more on retrospective fairness for past labor.
So copyright can be seen as a natural right, a societal incentive, or simply a fair reward for effort. Are these justifications easy to apply to UK law in practice? Do they fit neatly?
This is where the material gets into the critical analysis, and it's a key point for students to grasp. While these theories provide the reasons why copyright exists in general, applying them to the specific details of the actual UK law can highlight tensions and raise questions.
Like what kind of questions? Where does it get tricky?
We'll take the duration of copyright, for example, life plus 70 years. If the primary justification is utilitarian to incentivize creation, does a term that long really align perfectly with that goal? The creator is only incentivized during their lifetime, right? Does protecting the work for 70 years after their death significantly increase the incentive to create during their life? Or does it primarily benefit heirs or corporations long after the creative act occurred? It raises the question of whether the duration is perhaps longer than strictly necessary to achieve the incentive or reward goals.
70 years post-mortem does seem quite generous if the goal is purely about incentivizing the living creator. It makes you wonder.
It certainly prompts that question. Another area of tension is raised by the kinds of works protected under UK law, particularly with its historical emphasis on economic value and a lower originality threshold compared to some systems. If copyright benefits society by encouraging the creation of valuable works, how does protecting seemingly mundane items? The guide mentions things like examination papers, football pools, coupons, or professional directories fit neatly into the utilitarian or reward theories. Do these works truly require a potentially very long monopoly, life plus 70 years sometimes, to incentivize their creation, or do they contribute to cultural richness in the same way as a novel or song?
Right. It makes you wonder if the economic rationale sometimes overshadows the broader cultural or inventive goals of IP. Are these everyday items really what the Statute of Anne or the Berne Convention were primarily intended to protect? Seems unlikely.
Exactly. The material implicitly invites this critical thought, applying the theory to the reality of what the law actually protects and asking if the pieces fit together perfectly. The source also raises a concern about the constant expansion of copyright's boundaries over time. If copyright protection is always growing, covering new forms, extending duration, broadening restricted acts, is there always a clear justification for this expansion based on the underlying theories? This hints at concerns some commentators have about potential copyright creep or overprotection.
And the source mentions a specific prominent critique of this expansion by H. Laddie, a well-known judge.
Yes. The article by Sir Hugh Laddie, titled Copyright, Overstrength, Overregulated, Overrated, published back in 1996. While the material prompts students to summarize his points, the core insight from such critiques, as relevant to this discussion, is that they question whether the current state of copyright law has expanded beyond its original justifications. Laddie, for example, argued that copyright had become excessively long and broad, potentially hindering creativity and access rather than promoting them, suggesting it was overrated in its benefits compared to its costs. Referencing such a critique shows the material encourages you to see that the justifications aren't universally accepted as perfectly aligned with the current law.
So while copyright has strong theoretical justifications like incentive and reward, applying these theories to the practical details of UK law, its long duration, the breadth of protected works, and its tendency to expand reveals tensions and invites critical questions about whether the law is optimally structured to achieve those stated goals.
That's precisely the nuance the material presents in this section. It's not just about listing the theories, but thinking critically about how they map onto the reality of the CDPA.
Okay. This brings us to what the guide calls the fundamental principle underpinning copyright, and perhaps the most difficult to apply, the idea-expression divide. This sounds absolutely critical.
It is perhaps the single most important principle to grasp in copyright law, and it's been established for a very long time. The core concept is straightforward, in theory at least. Copyright does not protect ideas per se. You can have an amazing idea, a brilliant concept, a revolutionary method, but copyright protection only attaches when that idea is put into a tangible form, when it's written down, painted, composed, filmed, whatever. Copyright protects the work, and the work is the form or expression in which the ideas are embodied.
So the idea for a romantic comedy set in London isn't protected, but the specific script, dialogue, and plot of Love Actually is that specific expression.
Precisely. You can't copyright the general concept of a talent show, but you can copyright the specific script, music, and visual elements of a particular talent show episode as specific works. The material quotes Donahue v. Allied Newspapers from 1938, where the principle is clearly stated: copyright protects not the idea, but the expression of the idea.
And this principle isn't unique to UK law, right? It's a global thing.
Not at all. It's a fundamental principle recognized in international copyright law. Article 2 of the Berne Convention refers to the protection of literary and artistic works and uses the word expression. Article 9.2 of the TRIPS Agreement also explicitly states that copyright protection shall extend to expressions and not to ideas, procedures, methods of operation, or mathematical concepts as such. The EU Software Directive, which heavily influenced UK law, also explicitly excludes protection for the ideas and principles which underlie any element of the program, including its interfaces. This international consensus underscores how central this divide is.
Okay, so the principle is clear and widely accepted. Ideas are free, expression is protected. But the guide immediately dives into case law, which tells me applying this in practice isn't always easy. It gets messy.
Absolutely not easy. This is where the rubber meets the road, and courts have consistently struggled to draw a clear, predictable line. The source material presents several key cases that vividly illustrate this difficulty.
Let's look at the first one mentioned, Green v. Broadcasting Corps of New Zealand, the Opportunity Knox case.
Yes, Green v. Broadcasting Corps of New Zealand from 1989. This case involved the popular British TV talent show format Opportunity Knox, hosted by Hughie Green. The claimant, Hughie Green, tried to stop a New Zealand broadcaster from producing a show that copied the format of his show. Things like the specific catchphrases used. I mean that most sincerely, folks. The structure of the episodes, the way contestants were introduced and voted on, the use of a clapometer to measure audience applause. The defendant argued they had only taken the idea of a talent show format with certain common features.
They didn't copy a specific script for an episode or a recording of the original show, just the overall structure and repeated elements.
Correct. They created their own show, but replicated the key elements of the format. The court held that the format itself, consisting of abstract concepts, catchphrases, and structural elements, was not capable of being protected as a work listed in the Copyright Act, such as a dramatic work. They had only taken the idea of the format, not the protectable expression embodied in a script or a specific broadcast. The claim for copyright infringement failed because the court concluded that a mere format was on the idea side of the line.
Okay, so a TV format in that instance was deemed an unprotectable idea. Interesting. What about the Norosian v. Arcs Ltd case? That sounds familiar.
Norosian v. Arcs Ltd, Nota 2, around 1909-2000. This is another classic case highlighting the difficulty. The claimant, a film director named Mr. Norosian, had created a short film using a distinctive editing technique called jump cutting. This technique involved rapidly cutting between shots of a performer, making their movements appear jerky and impossible, almost like a strobe effect. The defendant, an advertising agency, saw Mr. Norosian's film and used the very same jump cutting technique in a television advertisement for Guinness.
So the defendant copied the technique used in the film, the editing style.
Exactly. Mr. Norosian sued for copyright infringement. His initial argument that they copied his film failed because the defendant hadn't made a copy of his film. They had filmed new footage with new actors and applied the technique to that. In later stages of the case, he argued the defendant had infringed copyright in his original screenplay, which is a dramatic work and is embodied in the film. He argued that the sequence of movements created by the jump cutting technique was part of the screenplay's expression.
And what did the Court of Appeal make of that argument?
The Court of Appeal dismissed the claim. They acknowledged the skill and effort Mr. Norosian had put into developing and applying the technique, even expressing some sympathy for his position. However, they strictly applied the idea expression principle. They concluded that the defendant had not taken a substantial part of the screenplay's expression. The jump-cutting technique itself was considered to be on the side of the idea it was a method, a style, a way of editing, rather than being the protectable expression of a dramatic work like a screenplay. The court distinguished between the skill in applying the technique and the protectable expression of the work itself.
That feels quite a hard line. Even a highly distinctive, skill-intensive technique was deemed an unprotectable idea because it was a method, not the specific expression of a work. Tough for Mr. Norosian.
It certainly demonstrates the strictness of the principle. Copyright protects the creative output, the script, the film, the song, but not the underlying methods, techniques, or ideas used to create it. The court felt bound by this principle, despite their apparent sympathy. The material specifically asks why the court might have been sympathetic, which is an invitation to reflect on the perceived fairness of this outcome from the creator's perspective, contrasting it with the strict legal principle being applied.
Okay, so Green shows format as idea. Norosian shows a technique as idea. Are there any cases where the line seems less clear? Perhaps where courts appear to protect something that feels closer to an idea, where it gets a bit fuzzier?
The source material points to Elenko v. Mandops from 1980 as a case where the line arguably became quite blurred and where the protection might appear to cover elements closer to the idea side.
What happened in the Elanco case, the weed killer leaflet one?
That's the one. This case involved a safety leaflet for a weed killer. The claimant, Elanco, had a patent that expired, allowing the defendant, Mandops, to start manufacturing the same weed killer. Mandops initially copied Elenco's safety leaflet verbatim and admitted this was copyright infringement. Fair enough. However, Mandops then rewrote their leaflet. Crucially, while they changed the literal wording and sentences, the new leaflet contained essentially the same information as Elenco's, presented in a very similar selection and arrangement.
So they changed the literal expression but kept the underlying structure and content, the substance of it.
Exactly. Despite the fact that the literal text was different, the Court of Appeal held that Mandops had still infringed copyright in Elenco's original leaflet.
How did they find infringement if the words weren't copied? That seems counterintuitive based on what we've said.
This is why the material presents it as potentially blurring the line. The analysis here is that the court effectively protected the selection, arrangement, and structure of the information in the leaflet, the underlying idea of how to present that specific safety information effectively, rather than just the literal words. It suggests courts can sometimes look beyond the surface literal expression to protect the non-literal elements of a work, like structure or organization, if they are considered a substantial part of the original expression. While legally it's framed as protecting the non-literal expression, in practical terms, it felt very close to protecting the underlying concept of how the information should be presented.
That really does show how tricky this distinction is, where protecting the structure feels very much like protecting the idea behind that structure. What about the high-profile Da Vinci Code case, Bagent and Lee? How did that fit in?
Yes, Bagent and Lee v. Random House Group Ltd. from 2007. This involved the authors of the nonfiction book The Holy Blood and the Holy Grail suing Random House, the publishers of Dan Brown's novel The Da Vinci Code. The claimants alleged that the Da Vinci Code infringed copyright by taking substantial elements from their book, specifically focusing on the general themes, concepts, and historical hypotheses presented in The Holy Blood and the Holy Grail, things like theories about Jesus and Mary Magdalene having a child, or the existence of the Priory of Sion.
So they weren't alleging copying of specific sentences or paragraphs, but of the core theories and concepts, the big ideas.
Precisely. They argued that taking these underlying ideas constituted infringement. However, the High Court at first instance, and subsequently the Court of Appeal, firmly rejected this claim. They held that even if the Da Vinci Code had drawn upon these general themes or concepts, they were simply too general, too abstract, and at too low a level of abstraction to be capable of copyright protection. They fell squarely on the idea side of the line. Historical theories or general concepts, even if presented originally in a book, are not themselves protected by copyright.
So taking the underlying concepts from a nonfiction work, even if those concepts are original to that work, is generally not infringement. That's a clear statement.
That was the clear finding. And the source material highlights a really crucial takeaway from this case, a comment made by Lord Justice Lloyd in the Court of Appeal. He explicitly stated that while the distinction between an idea and its expression is absolutely vital and central to copyright law, no clear principle can be laid down that will easily tell you, in every situation, whether something falls on the idea side or the expression side of the line. Lord Justice Mummery made similar points.
No clear principle can be laid down. That one sentence really encapsulates the practical challenge, doesn't it? It's a vital rule, but the boundary is inherently fuzzy and depends on the facts.
It absolutely confirms that applying this principle is inherently difficult and fact-dependent. These cases, Green, Nerosian, Alanko, Bagent, demonstrate that courts constantly grapple with where to draw this line in various contexts, whether it's TV formats, editing techniques, factual compilations, or historical theories.
Let's circle back to software for a moment. You mentioned the SAS Institute case earlier. How does that fit into the idea-expression divide?
Yes, the SE Institute Ltd v. World Programming Ltd case, which went to the CJEU and then back to the UK Court of Appeal around 2012-2013. The EU Software Directive, as mentioned, explicitly excludes protection for the ideas and functionality underlying a computer program. The CJEU confirmed that copying the functionality of a computer program, essentially, what the program does, its purpose and methods, was not an infringing reproduction of that program's expression, the code. This reinforced the idea-expression divide in the software context. The function or idea of the program is separate from the protectable expression, which is the source code or object code.
And the UK courts extended this principle beyond just software.
They did. When the case returned to the UK Court of Appeal, the court held that this principle, that functionality or underlying methods are not protected, applied not just to computer programs, but potentially to other types of works as well, even without an explicit directive requiring it for those other works. They reinforced the general idea expression principle, stating it applied across different categories of works.
So the principle that the underlying method or functionality is an idea, not protectable expression, is being consistently applied even beyond software where it's explicitly stated in the directive.
That's right. It's seen as a general principle flowing from the fundamental idea expression divide. And finally, the source material introduces a very recent development from the Court of Justice of the European Union that links the idea expression divide even more closely to the concept of originality we discussed earlier.
Originality and idea expression linked, how does that work? Sounds interesting.
This comes from the case C83388SI and Brompton Bicycles v. Chedek Get. This involved the shape of the famous Brompton folding bicycles. While design law was central, copyright in the shape as an artistic work was also considered. The CJEU, in its judgment, stated a principle with significant implications for originality. There is no originality and therefore no copyright protection, where the creation of a subject matter, the work's expression in this case, the shape, was dictated solely by technical considerations, rules, or other constraints that left no room for creative freedom, or where the room for freedom was so limited that the idea and its expression become indissociable.
That's a powerful connection. So, if the specific form or expression something takes is only the way it is because of its function or technical needs, and there was no real creative choice involved in its shape.
Then it's not considered original in the copyright sense because the idea, the function technical need, and the expression, the resulting shape, are so intertwined, so indissociable, that there was no scope for genuine creative expression. It's not just that the idea isn't protected. If the expression is the idea due to functional constraints, the expression itself lacks originality. It provides a new angle on why certain functional shapes or layouts might fall on the idea side, or rather fail the originality test, because the idea and expression are inseparable due to technical necessity.
Wow. So the inherent difficulty in drawing the line between idea and expression isn't just a theoretical puzzle, it's something courts constantly wrestle with, as shown in cases like Green format, Norausian technique, Elanco, where the line blurred with structure, and Bayesian, where general themes were clearly ideas. And now, with cases like Brompton bicycles, this difficulty is explicitly linked to the core requirement of originality itself.
Precisely. The source material notes that despite this inherent difficulty and the lack of a clear-cut test, acknowledged by judges like Lloyd L.J. and likely discussed by commentators like Spence and Endicott in the LQR article, mentioned the idea expression distinction survives and remains a fundamental principle of UK copyright law.
Why does it survive if it's so imprecise in practice? This is exactly the question posed by the sample exam question in the source. It seems like a paradox.
And the advice on answering that question points to the reason. The distinction persists because it's seen as a crucial part of the balance that copyright law must strike. On one hand, the law needs to protect the creator's investment in expressing their ideas, their skill, effort, and labor in writing that book, composing that music, or designing that illustration. Without protecting the expression, there's little incentive or reward for the hard work.
Protect the specific output, the work itself.
Yes. But on the other hand, society absolutely needs to be able to freely use and build upon underlying ideas. If ideas themselves could be locked down by copyright, progress in every field, science, technology, art, culture, philosophy, would grind to a halt. Every new creator would need permission to use existing concepts.
So, the idea expression divide is the legal mechanism for maintaining that balance. Protecting the specific form of the work, the expression, while leaving the underlying concepts, the ideas, free for others to develop and use.
That's exactly it. It's the law's attempt to manage that necessary tension. Even though applying the principle is notoriously difficult in practice, and cases like Elanco show how it can sometimes seem to extend to the arrangement of ideas, the principle itself that copyright is not a monopoly over ideas is considered essential for fostering continued creativity and societal progress. It's a compromise, messy in application, but seen as vital in principle.
That was a fantastic deep dive into the foundations. We've covered a significant amount of ground, drawing directly from the insights provided in this University of London material.
We've established the absolute basics, hopefully. We looked at the compelling history of UK copyright, seeing how it's been a story of constant adaptation, often reactive to technological change, and shaped by international pressures, from the Stationers' Company and the Statute of Anne, right up to the CDPA 1988 and the influence of retained EU law.
We compared copyright to other intellectual property rights, highlighting its unique features like automatic protection without registration, its emphasis as an economic right, and the crucial defense of independent creation, setting it apart from the absolute monopolies found in patents and registered designs. We also touched on its wide potential scope of infringement, the specific complexities with software use, and the possibility of criminal liability for commercial piracy.
We explored copyright as a valuable bundle of distinct rights, reproduction, distribution, communication, adaptation, illustrating how these can be separately licensed or assigned, using that clear example of the Harry Potter books. We also examined the relatively long duration of protection, life plus 70 years for most works, noting the historical complexities and how control can potentially be maintained through revisions.
We delved into the fundamental justifications for copyright, the natural law, utilitarian, and reward theories, and critically analyzed how well these theories truly align with the detailed specifics of UK law, prompting questions about the length of the term, the protection afforded to seemingly mundane works, and the rationale behind the continuous expansion of copyright, referencing influential critiques like that from Sir Hugh Laddie.
And crucially, we spent significant time on the foundational yet notoriously difficult principle of the idea expression divide. We saw how this distinction is central to UK law and international conventions, but how challenging it is to apply in real-world cases, illustrated by the specific facts and judicial reasoning in key cases like Green format as idea, Norausian technique as idea, Elanco, where protection arguably extended to selection arrangement, and Bayesian and Lee, themes as ideas. Remembering those names, Green, Norausian, Elanco, Bayesian, is really useful. We also saw the very recent connection drawn between this principle and the concept of originality in the Brompton Bicycles case, where technical constraints rendering idea and expression indissociable can defeat originality.
Looking back at the learning outcomes mentioned in the source, understanding the influence of technology, external forces, comparing different IP rights, evaluating the justifications, and discussing the idea expression divide and its practical application, it really feels like we've tackled the absolute core concepts this chapter is designed to introduce.
We have indeed. This foundational knowledge is not just academic, it's absolutely essential for understanding everything that follows in copyright law. Grasping what copyright protects, or doesn't protect, in the case of ideas, why it exists, and the debates around its purpose and scope, and particularly this central challenging principle of idea versus expression, is the necessary bedrock. It helps make sense of what works qualify for protection, which is the focus of Chapter 7, and what specific acts constitute infringement, which Chapter 8 delves into.
Exactly. It's the essential starting point that allows you to analyze complex, real-world situations and legal disputes involving copying, licensing, and creative rights in the digital age, from software interfaces to, AI-generated content these days.
Understanding these fundamentals gives you the framework to critically evaluate how copyright law operates and how it's constantly being tested and reshaped by new technologies and creative practices.
Absolutely. It provides the essential lens. For anyone studying this material, really engaging with the case examples we discussed, particularly those illustrating the difficulty of the idea expression divide like Green, Arausian, Elanco, and Bayesian and Lee, is vital. Pay attention to the specific facts and why the courts reach their conclusions based on that idea expression principle. Repeating those case names and their core point Green format, Norausian technique, Elanco structure info, Bayesian themes can really help them stick.
And definitely ponder that question of why the idea expression distinction persists despite its imprecision, as highlighted by the sample exam question. Connecting it back to that necessary balance between protecting expression and keeping ideas free is key. Also, reflecting on the Brompton Bicycles case and its link between originality and technical constraints provides a more contemporary angle on how these foundational concepts interact.
Fantastic. We've covered a lot of ground today, setting the critical stage for understanding UK copyright law based on the valuable insights from this University of London material. Hopefully, this deep dive helps solidify these foundational concepts for you. Remember, this was brought to you by Sinorbit Academy, Sri Lanka, and again, good luck to everyone with your exams.
We hope so. It's a complex area, but incredibly relevant in our creative and digital world. Best of luck.
As we wrap up this deep dive, here's a thought to leave you pondering. Given the relentless pace of technological change, constantly creating new forms of creative works and new ways to copy and share, and considering how inherently difficult it remains to draw a precise line between an idea and its expression, is copyright law destined to always be playing catch-up? And what challenges and opportunities does that ongoing tension create for both creators trying to protect their work and innovators wanting to build upon existing concepts in the future?
A dynamic challenge that won't be going away anytime soon, that's for sure.
Indeed. Thanks for joining us for this deep dive.
Until next time.